Welcome to the Insolvency Law podcast, providing specialist insolvency and debt-related advice for business owners and individuals. For more information on debt recovery, business restructuring, and personal and corporate insolvency, visit our website www.insolvencyandlaw.co.uk or call us now on 020 7504 1300.
Hello, and welcome to the Insolvency and Law Business Advice Show, the podcast dedicated to credit management, debt recovery, and insolvency in England and Wales. Today, we'll be discussing what company directors can do to prepare themselves for an examination or interview with the official receiver. Have you been summoned by the official receiver to attend an interview or examination? If you have, don't panic. You've come to the right place. This podcast summarizes how company directors can prepare for official receiver examinations and interviews. For more information on how to protect yourself from adverse proceedings, call 0207 504 1300 and speak with a professional independent advisor at Insolvency and Law. In most cases, people are usually summoned by the official receiver's office for two reasons. 1. They were recently declared bankrupt, or 2. They are, or have been, the director of a limited company that has been placed into compulsory liquidation. Most people are unprepared for their examination or interview, despite being notified in advance. Nevertheless, at Insolvency and Law, we can help you to consider your circumstances, plan, protect your interests, explain your actions, and avoid adverse proceedings. You will be required to complete a questionnaire detailing the financial and business activities of the insolvent company or person. Send the completed questionnaire to the official receiver in advance. Alternatively, you should have it ready for your interview or examination. Examiners look for evidence of misconduct. As a result, you may be questioned on a broad range of topics regarding the affairs of the insolvent company or person. The information you disclose will be used to explain to creditors the reasons why the company was wound up, or the person was made bankrupt. You will be questioned under oath. A refusal to answer may result in you being held in contempt of court, which is a criminal offence. Failure to attend an examination is also a contempt of court. So now you know the basics, let me tell you about the roles and duties of the official receiver. Whenever a limited company becomes the subject of a compulsory winding up order, the court will make a ruling to liquidate the company. Additionally, the Insolvency Service, the government agency responsible for protecting creditors and tackling financial wrongdoing, may investigate the reasons for the bankruptcy or company demise. The official receiver is an Insolvency Service employee and an officer of the court who is responsible for bankruptcies and company liquidations. They will appoint an insolvency practitioner to commence liquidation or bankruptcy proceedings, if there is an investigation to conduct, and assets to realize. Anyone involved with the company during the 3 years prior to its demise may be asked to attend an examination or interview. The same applies to anyone who has a relationship with an insolvent person in the period leading up to their bankruptcy. Sadly, we're coming to the end of this episode. But don't worry, if you need more information or guidance on examinations and interviews with the official receiver, simply pick up the phone and call 0207 504 1300 for a free and confidential consultation. Insolvency and Law is a multi-award-winning consultancy providing bespoke corporate advisory services to vulnerable company directors, business owners, and individuals since 2009. Speak with one of our professional independent advisors today. Regardless of your situation, they can help you protect your interests and avoid adverse proceedings. If you found this information useful, you'll probably enjoy some of the other shows in this series, especially the episodes on defending misfeasance claims and director disqualification proceedings. Thanks for listening to the end of this podcast. Goodbye.
Thank you for listening to the Insolvency and Law podcast. If you require additional guidance on any of the topics we covered today, visit the Resource Centre at our website, www.insolvencyandlaw.co.uk, or call us now on 020 7504 1300.